persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
All right, good morning, everyone. We're here this morning in South Marion Real Estate Holdings, LLC, doing business as Oxford Downs and Daryl Donnelly versus Florida Gaming Control Commission. And do we have Mr. Baxter? Mr. Morton, all right. And Mr. Morton, would you like 5 minutes for rebuttal or something different? Oh, okay. Right, and Mr. Marshman?
Good morning.
Good morning. All right. With that, you may begin.
Thank you, Your Honor. Thomas Morton with the Lockwood Law Firm in Tallahassee on behalf of the appellants. This case involves a challenge to a rule of the Florida Gaming Control Commission. It's Rule 75-11.005, subsection 5. This particular rule prohibits cardroom employees from participating in authorized cardroom games at the cardroom where they're employed. We've challenged this rule on two grounds. The first is that the rule exceeds the agency's rulemaking authority in violation of section 120.528B. And the second ground is that the rule enlarges, contravenes, or modifies the specific provision of the law implemented in violation of section 120.528C. I'd like to discuss the flesh left language in section 120.52. This is the language that establishes the requirements for an agency's ability to adopt rules. The flesh left paragraph generally requires two things. It requires a statutory grant of rulemaking authority, and it requires that the rule interpret or implement a specific power or duty in the enabling statute. Statutory grant of rulemaking authority is not at issue here. Generally, all agencies have that when the legislature authorizes an agency to administer or interpret a statute or enforce the statute. They say, this agency is authorized to adopt rules to administer this section. That's not at issue here. What is at issue is the second requirement of the flesh left paragraph, which is whether the agency's rule interprets or implements a specific power or duty in the statute. The rule itself cites section 849.086 in its entirety as the law implemented. That statute is the cardroom statute. It's a comprehensive regulatory framework that regulates cardrooms in Florida. It has 17 subsections. It's a rather lengthy statute. I've scoured the statute looking for a specific power or duty that would be implemented by the rule. I've been unable to locate one. The agency has landed on subsection 4A as the specific power or duty implemented. Subsection 4A is the agency's statutory grant of rulemaking authority. It basically says that the commission has the authority to adopt rules. What the agency is saying is that their rule, which is at issue in this case, implements the agency's power to adopt rules. That is not what the flesh left paragraph requires. The flesh left paragraph requires two things, both the statutory grant of rulemaking authority and a separate specific power or duty implemented.
To be fair, Counsel, it's the authority to adopt rules, including but not limited to the operation of a cardroom. That's what they've asserted, correct?
That's correct, Your Honor.
Okay. So would the contention then be that that grant of rulemaking authority lacks the specificity in and of itself to ever be the sole justification for a rule of any kind that the agency might promulgate?
Your Honor, that provision, the 4A, and it delineates certain, subject areas where they have statutory grant of rulemaking authority. That is the statutory grant of rulemaking authority. So to the extent they relied solely on 4A as to be both the statutory grant of rulemaking authority and the specific law implemented, I would say that they could not do so. They would have to go through the cardroom statute, 17 subsections, and pinpoint the particular provision that is tied into that grant of rulemaking authority that's being implemented. And I think in my reply brief, we kind of laid out a logical sort of correlation between those subject matters identified in 4A and the specific provisions in the cardroom statute that could correlate to that. So for example, in 4A, I think it says they have rulemaking authority over reports and record keeping, or something along those lines. There's a specific provision in 849.086 titled Reports and Record Keeping. I think those two would correlate. So if they find a power provision, or a power or duty in the record keeping subsection, it would tie in there. So I think it's laid out in a logical manner in that regard. But the requirement in the flush left paragraph to have both those things is important because the statutory grant of rulemaking is circumscribed by the law implemented. So if they just had a statutory grant of rulemaking authority that says you can adopt rules related to card room operations, that would basically be endless. But the flush left paragraph says it's not endless. It has to be tied into a specific power or duty. The specific language is that in the flush left paragraph states, statutory language granting rulemaking authority or generally describing the powers or functions of an agency shall be construed to extend no further than implementing or interpreting the specific powers and duties conferred by the enabling statute. I would note that the very same argument that the Commission is making here was made by its predecessor agency, the Division of Pari-Mutuel Wagering, in the St. Petersburg Kennel Club case. This was from 1998, second DCA case. The issue in that case was the agency adopted a rule defining poker. The rule was challenged as exceeding the agency's rulemaking authority. The agency landed on subsection 4A, essentially, as both the statutory grant of rulemaking authority and the law implemented. And the court said that statutory grant of rulemaking authority is not a specific law that supports the rule. It's simply a statutory grant of rulemaking authority. And the court pointed to the PPI decision, which was a year earlier out of the third DCA, as an example of where there is a specific law or duty implemented by a statute. The PPI case involved a rule that required card rooms to install electronic surveillance systems. And the court in St. Petersburg Kennel Club said that rule was implementing the agency's power to monitor the operation of card rooms. That's in 4B of the statute. So they weren't relying on 4A, the statutory grant of rulemaking authority as being the law implemented. They're relying on 4B, which was the power to monitor the operation of card rooms. And they said that rule was logically connected to that power. We don't have a similar power here, is our position. And there is some language about a clear logical connection. The clear logical connection applies to the rule and the specific power, not to the rule and the statutory grant of rulemaking authority. So I think the clear logical connection is a way to determine whether or not the rule enlarges, contravenes, or modifies the specific provision of law implemented. But if you don't have a specific provision of a law implemented, the clear logical connection analysis that derives from the St. Petersburg Kennel Club case, I don't think is applicable. And that, the ALJ in the final order did talk about a clear logical connection, but I think that was inappropriate because he was linking the rule to the statutory grant of rulemaking authority rather than linking the rule to a specific power.
But wasn't the St. Petersburg Kennel Club case talking about specifically what is the definition of poker?
Correct, Your Honor. And the court there said there was no specific power given to the agency that would authorize them to define poker or other card room games. And so I think in the decision, the court said an example of this would be if the legislature said the agency is empowered to define games that could be played in card rooms. And they said they weren't given that power, and so the rule was not supported by any authority in the statute. I've touched on the PPI case. Would like to direct your attention to, there's several provisions in the card room statute that specifically address who can participate in card room games. There's a provision that says no one under 18 can participate in the games. There's a provision that says dealers cannot participate in the games in which they're dealing. And there's a provision that grants authority to card room operators to further restrict who can participate in card room games. The legislature...
It sounds like you're proposing that the list in the statute needs to be absolutely exhaustive. Is that correct? We're talking about the operation of a business. So are you saying the statute needs to list every aspect of how you operate a business, whether or not it's prohibited, allowed, or prohibited before there can be any assertion of authority or rulemaking?
No, Your Honor, I'm not saying that. I think if there was something in the statute that said the agency may adopt rules relating to cardroom operations, including determining how cardroom games could be played or who can participate in cardroom or something along those lines. I think we could then maybe we're getting into the clear logical connection analysis. But it's not, the 4A is simply a statutory grant of rulemaking authority, and it's the only statutory grant of rulemaking authority in section 849.086. So it was intended to be the statutory grant of rulemaking authority. I don't believe it was intended to be anything beyond that. There are circumstances when within the statutory grant of rulemaking are specific powers and duties. And I can point you to the Florida Senior Living Association case that was cited by the ALJ. This is a first DCA case out of 2020. In that case, the agency was granted rulemaking authority, and then it said including but not limited to, and it lists many different powers. And one of those powers, and I'm going to paraphrase because don't have it memorized, but one of the powers was including establishing standards for the maintenance of resident records, residents in assisted living facilities. And so the agency adopted a rule that required assisted living facilities to maintain records of the treatment received by residents by third parties. And the court said that rule is valid because it's implementing not the authority to adopt rules, it's implementing the specific power to establish standards regarding patient records. So it said the agency has the authority to adopt rules, including but not limited to establishing standards for the maintenance of patient records. So authority to adopt rules, statutory grant of rulemaking authority, including but not limited to establishing standards for the maintenance of patient records, specific power or duty. And for that reason, the rule is valid. We don't have a similar specific power or duty here. The final order focused on, or determined that the rule is valid for a number of reasons. I think if you look at these together, it indicates a misapplication of the law. The first is that the final order determined that the rule regulates a basic aspect of cardroom operations. This analysis derives from a concurring opinion in a 2022 decision out of the first DCA. It's Escambia County School Board versus Warren, I believe. The problem with relying on that concurring opinion is that the concurring opinion determined the rule at issue in that case was based off in the agency's constitutional rulemaking authority. Constitutional rules are not bound by Chapter 120 or the flush left language in 120.52. So to the extent that the concurring opinion found the rule in that case valid because it regulated a basic aspect of school board operations, that analysis doesn't apply here. And to the extent that the ALJ relied on that, I think it's a minimum irrelevant, but potentially an error which requires reversal by applying a constitutional analysis to a statutory rule. Next, the final order determined that the agency has broad rulemaking authority, I think was the term. I'm not aware of anything such as broad rulemaking authority. The agency either has rulemaking authority or they don't. And this is under the flush left paragraph. And the Save the Manatee Club basically says it's not a matter of degree, either it's there or it's not. So this broad rulemaking authority concept, I don't understand. What was cited there was the Florida Senior Living Association case that I talked about a few moments ago. And I've explained why they actually had authority to adopt that rule. We don't have similar authority here. And finally, I think the final order made a finding that the rule furthers the legislative mandate to further public confidence in card rooms. This language was pulled from subsection 1 of the cardroom statute, titled legislative intent. The flush left language, and I'll read it, says, no agency, quote, shall have the authority to implement statutory provisions setting forth general legislative intent or policy. The final order, I believe, determined that the rule furthered the legislative intent, and I believe that was in violation of the flush left paragraph. If the court doesn't have any other questions, then I will, for these reasons, we ask that the court reverse the final order of the ALJ and invalidate the rule as an invalid exercise of delegated legislative authority.
Thank you.
Thank you.
Mr. Marshman?
May it please the Court. Good morning. My name is Ross Marshman, and I represent the appellee in this case, the Florida Gaming Control Commission. The issue in this case is really whether the challenge rule is a valid exercise of delegated legislative authority or not. And during my time today, I will explain why the appellant's two objections are unavailing and why the ALJ got it right and why the appellants got it wrong. So from the outset, I think it's important to recognize that the Commission's authority and duty to exercise strict control over the operation of card rooms goes back to at least 1997, which was the PPI case that the Appellant's Counsel has already described. That court's recognition stems from two provisions of law, sections 550.0251 sub 12 and section 849.086 sub 4. Both of those statutes state that the Commission has the authority and the duty to regulate the operation of card rooms. The Commission's grant of rulemaking authority is flexible and open-ended in this case. That is not to say that there is limitless rulemaking that is possible for the Commission. We are only concerned with, however, the two objections that were raised by the appellants in this case, whether it exceeded the grant of rulemaking authority and whether it enlarges, modifies, or contravenes the statute it was designed to implement.
Mr. Marshman, can we start with what I think is perhaps a beginning premise of your friend on the other side, that the grant of rulemaking authority and then the specific statutes to be implemented must be distinct and in different subsections, right? So the Commission has cited as the authority, 4 sub A, or excuse me, 4 sub A, and your friend on the other side indicates that that in its entirety is simply a grant of rulemaking authority, but it must be tied to another provision of law. Can you walk us through your perspective on that, and can you point us maybe to another statutory regime where the legislature has both conferred rulemaking authority and provided a specific statute to be implemented in the same subsection of a statute? Are you aware of an example where the legislature has done that? I guess it's a two-part question.
So answering the second part of the question first, in the beverage law for the state of Florida, there are specific provisions that are both granting the Division of Alcoholic Beverages and Tobacco, a division of the Department of Business and Professional Regulation, not only the specific grant of rulemaking authority, but also a specific provision to implement. For instance, the labeling requirements or the brand registration requirements. Those are something I think that is present in the beverage law. But answering the first part of your question, which is, does there have to be this separation between the general grant of rulemaking authority and a specific law to be implemented? I think that the appellant's argument is focused too much on 4A itself, which I agree does specifically give the Commission the rulemaking authority to regulate cardroom operations. But in subsection 4, right above, there is a duty of the Commission to regulate the operation of cardrooms itself. So I don't necessarily agree with the appellant's point that there is just one line here that is stating what the authority is of the division. I think there is a specific explicit duty of the Commission to regulate card rooms, and then there is a separate authorization to engage in rulemaking that authorizes, or strike that regulates the operation of card rooms. So I think there is some distinction there. Does that answer your question, Judge Pratt?
I think so, yes. You can continue.
The types of rulemaking restrictions that were present in other cases are not present in this case. Take, for instance, Day Cruise Association. There was an express language in the grant of rulemaking authority that a rule could not do something. And the Board of Trustees for the Internal Improvement Trust Fund did that thing. They impacted commerce when the specific grant of rulemaking authority stated you could not do that. So when the Commission writes in its brief and argues today that there is not that type of restriction, it's open-ended, that's what the Commission is meaning. We are not arguing that we are somehow outside the confines of Chapter 120 and that we're outside Save the Manatee and its progeny. We are fully within those confines, and we are satisfying those confines. Just like it isn't a problem to call the rulemaking open-ended, it isn't a problem to call rulemaking in this case flexible. The appellant has already cited to the Senior Living Association case. In that case, the grant of rulemaking authority included the same type of language that is at issue in here today.
When you say flexible, you're also using, I believe, by implication, general, non-specific? I mean, here it says, and taking your argument, 4A, the operation of a card room. I mean, we could be talking about, you know, like, as in here, who can and cannot participate in it. Obviously, there's a specific restriction on minors not being allowed, the dealers not being involved in the game. It seems like this, where you're saying a employee who was off the clock or not at work cannot be involved. That's not in the statute. So I guess it's your 4A is more general, is what I'm saying, or non-specific.
I think that the statute does not have to spell out every conceivable topic for rulemaking. I don't believe that is required by Section 120.52 sub 8's flush left paragraph that the appellants have already talked about. In fact, the language of the statute that was quoted by the appellant includes the term interpret. I believe that interpret means something as described in Save the Manatee, which means that it can be more detailed, for instance, than the statute. I think this court has made that point previously in the Sierra Club versus St. John's River Water Management. There does not have to be a direct one-to-one relationship between a statute and a rule. If there was no need for rulemaking. Flexibility is a good thing. The Florida Supreme Court has argued, has discussed that in the case Wiley v. Scott in 2011. A delegation of legislative authority allows an agency with expertise and flexibility, that's their term used, to address complex and fluid situations. So again, open-ended, flexible, these are not negative concepts that can be applied to rulemaking. They just have to be taken into consideration with, as the appellants have pointed out, the flush left paragraph of Section 120.52 sub 8.
Could you give us an example of a regulation, whether actual or hypothetical, that does not implement the Commission's authority to adopt rules regulating the operation of a card room?
I can have a hypothetical rule. Say, for instance, the Commission issues a rule that states that no one in a card room can wear a red shirt on a Tuesday. I don't believe that that is tracking back to the language of the operation of the card rooms, but I don't know if that's necessarily because it exceeds the grant of specificity. Strike that. I don't believe it violates 120.52 sub 8 sub B, but I think that there are other limits to a Commission's rulemaking authority that would curtail that Commission's rule. And that it can't be arbitrary and capricious, for instance. That's later on in sub 8. So I think there are limits on what card room operations mean, but I think those limits can be found elsewhere in the statutes, like if it's void for vagueness or unbridled discretion, for instance. There are limits on the Commission's rulemaking, but those limits were not raised in this challenge. The unbridled discretion, the arbitrary and capricious, that was not raised in this case. You have two specific objections, that it exceeds its grant of rulemaking authority and it enlarges, modifies, or contravenes the language of the statute that it was designed to implement. What the appellants are arguing about, and I think Judge Wallace, you touched on this in your questioning, is the appellants are looking for a specific enough grant of rulemaking authority. But that is not what the language of Section 120.52 sub 8, that flush left paragraph, that's not what they're talking about. They are talking, like the appellant said, whether the rule is authorized or not. The degree of specificity is irrelevant. The correct question in this case is whether the challenge rule is supported by the specific grant of statutory delegation of rulemaking in this case, and the answer is yes, for the reasons that the ALJ outlined. What is more fundamental to the operation of a card room than who can or cannot play at a card room? And that basic analysis, that basic framework analysis can be found in other cases. For instance, the Dania case. While the rulemaking in that case was flawed, it was flawed by a matter of procedure, not because the Division of Parimutuel Wagering, my predecessor agency, lacked the sufficient authority to regulate in the card room space. In the Dania case, they confirmed that the operation of cardroom regulation the commission was allowed to do could include the basic framework for permissible play of cards games.
So just to make sure that we understand correctly, your argument is the argument, regarding the various subsections that expressly state who can and cannot play, right? Minors can't play, for example, that the statute provides a floor of regulation beyond which the commission can go and add in the exercise of its authority to regulate the operation of a card room. Would that be the correct way to state it, or is there something that I'm missing?
The commission is not trying to exceed its authority to regulate the card rooms as spelled out in section 849.086.
I'm talking about specifically about the issue of who can play and who can't, right? The statute does have some things to say about that, right? Is the contention then that the commission does have the authority to add, categories of persons who cannot play when the statute enumerates, 2 or 3 categories of individuals who cannot already?
I believe that it's important to examine what the language is exactly of 849.086 sub 7 sub G, which is talking about a limit on against whom a card room can discriminate. Age, race, national origin, those types of immutable characteristics. So I don't see that provision as a limit on who can or cannot participate in a card room.
That's fair. But on sub 12 sub B, no person under 18 years of age may be permitted, right, to hold a license or to engage in any game. Right, and that does not give discretion to the card room operator, and it's a closed class of individuals that are just statutorily straight up prohibited from participating in the game. Right, so I'm just working through sort of your friend on the other side, is availing himself of these particular subsections, and I understand your point with regard to empowering card operators to refuse entry to certain persons in their judgment. That's a separate question, but on the question of minors, we have a statutory prohibition, right? And from that, your friend on the other side would have us then infer that whatever regulating the operation of a card room might mean, it would not entail adding to the statutory list of prohibited persons the commission's own list, right? Could you walk us through how you approach that?
Well, I think it goes back to what is the operation of a card room or the regulation of the operation of a card room. There is an age restriction. The commission is not ignorant of that fact. However, what we're talking about here is prohibiting a individual occupational licensee from participating at a card room at which they are currently employed. I see that as a distinct concept or a distinct subset of what is card room operation. So there is more than just setting the floor. There are other types of restrictions that I think the legislature delegated the authority to us to consider. I don't think that's adding anything to that age-based restriction. It's just an additional, well, not additional, it's just another concept to be explored when it comes to the regulation of card rooms. And again, it's a fundamental concept or a basic aspect of the card room operation that we are allowed to regulate, which is who can or cannot play there. And we are not regulating the general public so much as we are regulating an individual occupational licensee, and we are also regulating an individual licensed card room. We are not touching on the general public at large. We're not concerned about someone's age, for instance. We're talking about licensed facilities and licensed individuals.
So is it your position essentially that prohibition, so prohibiting a licensed dealer from playing in the same card room, that would essentially be less expansive than operation? So if we're looking at operation of a card room, is it your position that prohibition of certain participants would be a narrower category, so captured within operation of a card room?
Yes, I would agree with that.
And you would urge us not to apply something like the expressio unius est exclusio alterius canon on the basis that it is conceptually distinct to say who from the general public is proscribed from playing a game, and then who, in terms of an occupational licensee, is prohibited from playing in the game. That those are conceptually distinct, and for that reason, that's the reason that you would have us not apply the canon that your friend on the other side would have us apply. Is that an accurate way to say?
I agree with that. I think that interpretive lens only applies if we're talking about a list of the same subject matter. And I see these as you said, Judge Pratt, two distinct areas that cannot be combined, and so the inclusion in one is to the exclusion of the other. I don't think it's fair to read that provision of Section 849.086 in harmony like that. And to the appellant's point that they're making, that they've suggested in their reply brief that there is a way to read 849.086 sub 4 sub A as being defined by the later sections of the statute, that is exceeding the scope of the statute itself. There is no express language in 849.086 sub 4A that states the operation of the card rooms as defined later in sections 7, 8, 9. I think that's going a step too far. I don't think the legislature made that type of connection there to where those are the only types of regulation of card rooms that could be there. I think that there is something that we could have a logical connection with, and like in this case where there is the fundamental aspect of the operation of a card room that we can regulate based on this legislative grant of authority. If this panel has no further questions, for the reasons that I've discussed today and for the reasons in my brief, this court should affirm the lower tribunal's final order. Thank you.
Thank you. Mr. Morton.
Just want to touch on a few points. So the issue of strict control of card rooms, the legislature contemplated that. They put it in the legislative intent, and they decided to give the authority to further restrict to the card room operators. And the language that allows card room operators to further restrict says they can restrict any person. They don't mean just people who don't work there. It means everyone. So they can determine in their discretion what is the best way for their card room to operate in terms of who can play those games. If they think that employees should not be able to play, they can do that. If they think it's okay for the employees to play, they can do that as well. So that provision says they can prohibit anyone. And I think the fact that the legislature contemplated giving that power to someone and gave it to the card rooms and not to the commission is important. And it goes to your point, Judge Pratt, about the canons of statutory construction and proper interpretation.
But there's nothing logically inconsistent, though, with saying that card room operators retain discretion to, refuse entry to someone that they've deemed problematic, and to also say that the commission has some regulatory authority in that space, right? I mean, why is it logically inconsistent to say both that card room operators and the commission can outline categories of individuals unable to play, especially when it regards the licensees rather than members of the general public?
Sure. So I agree that they could have done both, but they didn't. They did not give that authority to the commission. Now, if we're interpreting regulating card room operations as meaning that, then I guess they do have that authority, and I don't see any reason why, from a logical standpoint, they couldn't have given it to both. I just don't think they did. They plainly gave it to the card room operators. In my opinion, it's a big leap to say card room operations means regulating who can play those games when they didn't do that and they gave it to someone else. And I would note the question about a hypothetical rule. Mr. Marshman identified a rule that said no one could wear a red shirt in the card room. But he didn't say they couldn't adopt that rule because it exceeds their authority. He said because it was arbitrary and capricious, which suggests to me they have authority to adopt anything. Now, he's right. The rule can't be arbitrary and capricious. But that's a separate analysis from whether they have the authority to adopt it. And, I would note that the notion of the fundamental aspect of card room play, in this rule being a fundamental aspect of that derives from the basic aspect of card room operations analysis, which I mentioned is derived from a language reviewing a constitutional authority of a rule. It has nothing to do with the Chapter 120 rule. So that analysis is I don't think it's applicable at all. And second on that point is St. Petersburg Kennel Club case. They said the agency can't even define the games that are played in card rooms, let alone who can play them. I would say that's a more fundamental aspect of card room operations, and the court said they can't do it. So for those reasons, Your Honors, if there's any other questions. For those reasons, Your Honors, I'd ask that you reverse the final order and determine the rule to be an invalid exercise of delegated legislative authority.
Thank you. All right. Thank you both very much. Excellent arguing. And with that, we will stand in recess.